Well, it's the last day of summer. The sky is sunny and blue. The trees, the leaves are changing their colors. And I wanted to give you a little bit of a recap on this historic day in the Ontario Court of Appeal, heard at Osgoode Hall in Toronto on Thursday, September 19th. But before I get into that recap, I'll just remind everyone, if you want to help out in these fighting this legal machine, you can go to nomorlockdowns.ca. You can follow me on Substack Randy Hillier, as well as my YouTube, Twitter, Facebook accounts, all under the name Randy Hillier. And I also have a Give, Send, Go page, and I'll include these links in the posting. So let's go back to Osgoode Hall yesterday. And just as a brief recap, my constitutional challenge against the Reopening Ontario Act and these horrendous mandates during COVID was initially struck down by Justice Callahan earlier this year. We sought leave of appeal. The Justice Center for Constitutional Freedoms is representing me on this argument. And yesterday, although I didn't have much optimism going into this appeal, and I think everybody can understand why we wouldn't have much optimism. Our courts have not been friendly to freedom. The courts have not been interested in finding a remedy or defending freedom here in Canada. So we weren't, it was like a Hail Mary. But lo and behold, I was quite impressed. These three justices that heard the arguments yesterday, Justice Lauer, Pomerantz, and Kazdan, I believe is how you pronounce the other one, and it was held in this prestigious and august Osgoode Hall, downtown Toronto. So it boils down to these two things. Did the Reopening Ontario Act, everybody agrees that it did, of course, impugn our charter-protected rights. Nobody's not questioning that. But it comes down to, was it a fair and reasonable and demonstrably justified infringement? And so one of the things in our Constitution is a categorical recognition that no one right trumps or supersedes another right. So in brief terms, the right or the freedom of mobility does not trump the freedom of expression. The freedom of expression does not trump or subservient to the freedom of religion. The freedom of religion doesn't trump the freedom to peacefully assemble and gather. All these must be held to the same high level of regard and protection. And what we saw during COVID and this Reopening Ontario Act, and where the government is weak, is they carved out exemptions for all other freedoms. The freedom of worship, even though it had very, very limited, I think at that time, churches were allowed to have maximum 10 people in their church. Stores were allowed, some stores were allowed to be open, but they had capacity limits on it. Some hockey games were allowed to be played, but capacity limits and infringements. There was a whole number of mobility was restricted. You weren't allowed to leave your home except for under strict provisions for receiving health care or food. So all those rights were infringed upon, but there was some level of exception or exemption to them, but not the charter-protected freedom of peaceful assembly to protest government regulations and laws. In that case, nobody was allowed to leave their house in Ontario to protest the government law. And what the legal counsel did a fine job on is showing and demonstrating to the three judges that the government placed these other protected freedoms, like worship, at a higher level than they did for peaceful assembly. This struck a strong chord. I think it struck an extremely important chord with Pomerantz, because she was one of the judges who came down hard on religious institutions for exceeding the 10-person limit. And I would say, Justice Pomerantz probably comes from, it doesn't come from the school of hard knocks, but maybe it comes from the school of liberal arts and gender studies, and maybe is a little bit more left-wing than myself or some of the other people who may be listening to this. So she was put, this is a bit of a conundrum for the left-wing judges. Are they going to recognize that the freedom of worship should be protected, but not the freedom of protest? If that's true, what happens to all their favorite little protests like BLM and gay pride parades and all that other deviant stuff? So I think the justices are going to be really hard-pressed on saying that there can be a complete extinguishment of peaceful assembly, but not of other rights. And I think the other element of that is just that, is, was it a minimal impairment that zero people could go outside to protest government policies and laws? And of course, how can you ever come to the belief or understanding that when an activity is completely extinguished, criminalized, that it is minimal impairment? So I think these three judges down at Osgoode Hall got a good lesson, and I was quite pleased at the level of inquiry, the level of inquiry, the level of interest shown by the three justices on the Court of Appeal. And I suspect, I'm going to remain optimistic that we may actually see in this country, finally, a constitutional win in our courts that will strike down the provisions of the Reopening Act that were made during that counterfeit period of time, that outrageous and exaggerated period of time, otherwise known as COVID. So stay tuned. I suspect that we will have the decision, hopefully within 30 days or maybe 45 days. But if we win, many convictions will be overturned. Many other charges that remain outstanding for many other people will be withdrawn. And we will be able to hopefully, be able to plant the flag of victory and claim September 19th as a historic day for freedom in Canada.